Welcome everyone to today's webinar, Drug Testing in the Workplace, presented by Barclay Damon. Many thanks to our presenter, Michael Sciatti, and Christopher Harrigan for being with us today, and to all the participants who have joined in, and to our educational series sponsor, Chemung Canal Trust Company. Please note this webinar is being recorded to share what we learn with the business community. All attendees will receive the link to the recording. Michael and Christopher will share the presentation with you, then follow with time for questions and discussion. Please use the chat to submit any questions during the presentation. Just a reminder, when others are speaking, please keep your audio on mute to minimize background noise. With that said, I'll turn it over to Michael to start things off.
Great. Good morning, everyone who in attendance. And we realize, I think most people will probably be watching this recorded later on. So hello to all of you as well, whenever you may be watching this. Our topic today is drug testing in the workplace. And we've packed a lot into this, just so you're aware, as the agenda will show you in a second, will indicate. You know, I usually don't say much about a disclaimer other than in this particular case, you really need your drug testing policies and procedures and related policies reviewed by legal counsel. You got to get this right, because if you get this wrong, there are going to be serious repercussions to you. Here's Chris's contact information and my contact information. I'm also on LinkedIn and Twitter if you wish to join the network. Those of you that aren't able to ask a question because you're reviewing this in a week or whenever, you know, feel free to reach out to us if you have some general question that you need answer. Send it to both Chris and myself, and one of us will get back to you in that regard. Our agenda today is fairly aggressive. We're going to give you an overview of the Marijuana Regulation and Taxation Act. Very generally, we're going to concentrate more on the employment implications of it. We want to address who's a covered employer and covered employee under the law as it relates to the ban on drug testing as to marijuana, and we'll walk you through who's covered and who is not. The recreational use of marijuana outside of work, without the company property, and during non-work hours is now a protected activity. So Chris will walk through the new law, the amendment to the recreational activities law, what it means, what the exceptions are, etc. I'll come back and I'll talk to you about some drug testing considerations and workplace policies that you should consider implementing. Also, we sent out a appendix. It's entitled the Reasonable Suspicion Checklist. As both Chris and I will mention to you today, there's things called specific articulable symptoms. There's a lot of them, and we believe the checklist is one way for you as an employer to document those. So with that, I'm going to mute myself, Chris, and I will turn it back over to you in that regard. So I don't seem to be muted. Well, all right, I'll just be quiet. Hold on. Mute.
Okay, thanks everybody. Thanks, Mike. We're going to go through the Marijuana Regulation and Taxation Act. I'll call it the MRTA for short. And the new normal. Here we are. This picture was taken from a production floor of a client of mine a couple of days ago. Now I'm just joking, but this is what everybody thinks when they think of the MRTA. That this is going to be what break period looks like, and this is it's going to be craziness. Not necessarily the case. We're going to go through some of the specifics with you today. So just by way of overview, the MRTA signed into law by Cuomo back in March of 2021. There are some provisions that became effective immediately, and there's others that we're still waiting on. We thought might have been in place right now, or it looks like they're going to be a little later, whether it's the end of this year or maybe sometime in 2023. And we'll get into some details on that in a little bit. So just generally speaking, some of the things, and a lot of you may know this, but just to go through it, now adults over 21 can purchase marijuana for recreational use. As we all know, and we've probably read about, there's the issues of licenses and how that's going to happen. There are no dispensaries that are currently open yet in New York State, but they're on their way. The MRTA also allows for some limited home growing. And then more importantly, which was one of the reasons that this was passed, was that it's going to theoretically create some income streams that are going to provide lots of money for education, drug treatment programs, and state and local governments to add to their tax coffers. There's also the establishment of the Office of Cannabis Management. So this is, it's an entity that's under the purview of the New York State Liquor Authority, one of the great draconian agencies that we have here in the state of New York. And now cannabis, of course, is going to be run under that scheme as well. The MRTA is going to expand the medical marijuana program, and we'll talk a little bit about that in more detail as we go through our slides. One of the other things that you may have heard about, and again, this was a factor in this getting passed, and it was championed by a lot of our state legislators that come from areas and constituencies that have high rates of conviction and criminal records. There's going to be an expungement of those criminal records as it relates to marijuana offenses. So, this is going to affect background checks, criminal conviction inquiries, and then also you have to remember, as it relates to background checks and criminal conviction inquiries, some of you may have local laws depending on where you are. There are certain cities, certain municipalities that have laws in respect to what is and what is not in a criminal background check, and what you can and what you can't ask for. So, be aware of that going forward. It's unclear whether all of the criminal records in respect to marijuana have been expunged at this time, but some definitely have. If you see something that comes up in respect to a marijuana conviction on a criminal background check that you perform for an applicant, just make sure to measure twice and cut once, because that may be next in queue if it hasn't been eradicated already. So there's a licensing system. You've probably read quite a bit about this as well. It's not up and running in total yet, but it has started a little. There's a huge push for social and economic equity that is literally taking into account what zip code you live in, where your proposed dispensary is going to go, and then what your background is. Are you a woman? Are you a minority? Are you a person who's a part of a demographic that's been disproportionately impacted by marijuana laws and criminal convictions? If you are, the state has set aside a huge number of the available licenses to be granted to those individuals. So it's an interesting time right now we've got in the state in respect to when this is all going to get up and running. We're still waiting for all of the licensing and some of the other specific regulations to drop, so that we can see the brick and mortar dispensaries start opening up in different communities. So, as I said, very interesting times. And this is, again, theoretically big business, right? So according to the state, they're anticipating that by legalizing recreational marijuana, it's going to be an annual tax haul of $350 million. We'll see. And then also they believe it's going to be the creation of 30 to 60,000 new jobs in the state of New York. And again, there's a whole vertical. There's not only those that are going to sell in a retail space different marijuana products, but it's also the growers, it's also the distributors, and then it's all the ancillaries that come off of that, whether it's security, or marketing, or other types of jobs that'll be related to or surrounding this big business. It's no surprise either. The money is so big, and more importantly, and something that you hear all the time, we're surrounded by states that are all now either online or soon to be online with recreational marijuana. There's for anybody who's been east and knows of Lee, Massachusetts. Lee, Massachusetts is about, I think it's 5 miles just east of the New York border. And Lee has his dispensary there, which is frequented by many people. I would say Syracuse and southern tier east to go there. New Jersey is now online. Pennsylvania is getting ready to go online. And so we're surrounded. So we're losing that tax revenue, that sales tax revenue every day that we're not open for business here in the state of New York. And then one of the other things that's going to happen here is that we're going to talk about is in respect to medical marijuana is that the Compassionate Care Act sunsetted. So they had to do something in respect to medical marijuana and the Compassionate Care Act. And that's all wrapped in with the MRTA. So in terms of medical marijuana, and again, just as a refresher, some of you may run into this in the workplace for individuals that you employ that have medical marijuana cards. So back in July of 2014, Governor Cuomo signed the Compassionate Care Act, and it's expired in July of 2021. So just to give you an idea, okay, what this new MRTA did is it resets, if you will, the medical marijuana and the allowance for medical marijuana in the state of New York. But just to give you an idea of where we think this is going for recreational, we are able to give data in respect to the users and prescribers of medical marijuana. So just as an illustration, there were 816 healthcare providers that registered for New York's medical marijuana program as of July 9th, 2017, right after it came online. So if you fast forward to April 5th, the last time we had data that we could draw from the state, that number has jumped to 3,645. Huge. Even more huge are these numbers. So back in July of 2017, you had 12,247 patients that were certified by those healthcare professionals as being eligible to use medical marijuana. Fast forward 5 years later in April of 2022, and it's over 125,000 patients. So again, that's just on the medical side. We think on the recreational side, those numbers these numbers are indicative of how popular and wide used recreational marijuana is going to be once it comes fully online, and people are able to go to that dispensary in their locality to be able to buy recreational marijuana. So some of the changes to the medical marijuana program, there's going to be more conditions that qualify. It was pretty strict in the beginning. That's going to be loosened. That has been loosened quite a bit. The number of caregivers have been increased. They've expanded it to allow additional caregivers to be able to prescribe medical marijuana. There's going to be more ways, more forms of medical cannabis. It's not going to be as restricted in terms of the mediums in which it would be able to be produced and distributed. And then there's also some home cultivation that's going to be allowed, which, again, interesting, probably not something that's going to be particularly relevant or germane for everybody on the phone purposes, but just as an FYI, it's an interesting development. So the next thing we're going to talk about, because this is really where what we care about is the covered employers and employees and what you can and what you can't do. So let's go through some Q&As, which are helpful. So in respect to covered employers, the question is both public and private employees, are both public and private employees covered by the MRTA in New York, in the New York State Labor Law 201D, which is the recreational activities law that we'll talk about in a little bit detail. And the answer is this, the answer is yes. They apply to everybody. It's public, private employers, New York State, and again, whether you've got one employee, regardless of what the industry is that you have or what the occupation is, you're covered. And also, which employees are not covered by the MRTA and the Labor Law Section 201D. And so the answer is they do not apply to individuals who are not employees. So those include students who are not employees, independent contractors, individuals working out of familiar obligation, volunteers, and employees under the age of 21. The MRTA does not apply to those individuals. Those individuals are not considered employees for purposes of this law. Immigration status. Do these laws depend on immigration or citizenship status? And the answer is no. These new laws apply to all employees, regardless of immigration or citizenship status. If you're a W-2 employee, you're not under 21, you don't fall into one of those 5 categories on the last slide, you're covered. Those individuals are covered, and you have to, you're obligated to conform with the statute as it relates to those individuals. What about non-New York employees? What if I've got somebody that works remotely in another state that uses different laws? And the answer is the MRTA, it only applies to employees who are within the state of New York. So if you've got someone who's in another state, then this does not apply to them, not until they come into the state of New York, whether to come back remote to work from a remote assignment, or if they come into the state at any time to work back for the company. So what about leave? Can somebody use cannabis if they are on leave? And the answer is yeah. You can't. Employers cannot prohibit the use of cannabis while somebody is on leave, unless they're permitted to do so pursuant to the provisions of 201D. And we're going to talk about that. We've got some slides that are going to go through that you'll see what I'm talking about. But if somebody's on leave, if somebody's not working, you can't say to somebody, unless they fall into the exceptions, you can't have a policy anymore that says use of illegal drugs or use of cannabis is no longer prohibited, because it's not illegal anymore. So the next things we're going to talk about here is cannabis as protected recreational use. Okay, so the MRTA expands protections of Section 201D of the New York State Labor Law to include legal use or possession of marijuana while off duty or outside the workplace. Okay, so think about it this way: what the MRTA did is it literally amended 201D of the labor law. 201D of the labor law is the recreational activities law. And when we think of that in the traditional sense, prior to the MRTA, we think about things like your political affiliations, what you do on the weekends in respect to your recreational activities. You can't punish somebody for drinking alcohol or going to being a part of a certain organization, or what political party they belong to, or whatever the case may be. Obviously, there's exceptions to that as it affects the company, but you can't. There's certain protections under the recreational activities law. Now that includes the legal use or possession of marijuana while off duty. That is now a protected use under the recreational activities law. So that includes legal usage prior to the beginning or after the conclusion of the employee's work hours, off the employer's premises, and without the use of the employer's equipment or other property. So that's important. Let's look at that again. There's 3 important things here. So it's okay to use marijuana if it's prior to the beginning, prior to the start of when they're working, after they're done working, but it's got to be, you can't do it on the place of employment. You can't get off your shift on the production line, go run out to your car and light up a joint in the parking lot. That's you can have policies that say there's no recreational, there's no possession or use anywhere on company property. That's totally fine. That's completely acceptable. And then also, if somebody has employer equipment like a company car, it's okay to say you can't possess or use marijuana in the company car. It's the company car. It's not their car. That's okay. And that's totally acceptable under the law. So again, we'll talk about in a little bit the fact that just because it says prior to the beginning of somebody's shift, it doesn't mean that 2 minutes before they get out of that car to go on the production line to check in for their morning shift, that they can go, fire up that joint, get high as a kite, and come to work. That's a no-no as well. We're going to talk about that a little bit more in detail, but what it does not mean is that people can come high to work. We'll talk about that in some more detail. In addition, the MRTA provides that an employer has got to adhere to the policies regarding cannabis use in accordance with the recreational activities law. And in this regard, no employees shall be subject to disciplinary action by a business solely for conduct permitted under the MRTA. So again, what this means is, in the past, theoretically speaking, if somebody was using marijuana and you found that use because of a drug test, and that was against public policy, that could be grounds for discipline or up to and including termination. No longer, unless you fall under one of the exceptions, that's no longer the case. And make sure that y'all understand that. Unless you fall under an exception, testing for marijuana and having a positive test, unless you fall under one of the exceptions that we're going to talk about in detail, you cannot, it is illegal to use that as grounds for not hiring somebody, disciplining somebody, or discharging somebody. Can't do it. However, there are exceptions, and there are 3. So you can continue as an employer to take disciplinary action against employees who engage in off-duty cannabis in 3 situations. Number 1, if the employer's actions are required, if discipline or discharge or not hiring are required by state or federal statute, regulation, ordinance, or other state or federal governmental mandate. So if you are mandated because of the type of job, your business, whatever the case may be, if you are required by law to test and discipline and or discharge in the event of a positive cannabis test, positive marijuana test, then you can continue to do that if you are required to do so by law, regulation, ordinance, whatever. That's okay. That continues. Number 2, if the employer's actions would require that the employer disciplines or discharge, it's going to cause you, if not disciplining and not discharging because of marijuana use that you know about, is a violation of federal law or would result in the loss of a federal contract or federal funding. If you become aware of cannabis use and then not doing something, not taking disciplinary action, including termination, would cause you to be in violation of a term of a federal contract, or you would lose federal funding, then you can go ahead and discipline and discharge. That's exception number 2. So that's what we call, it includes state, but we call them the 2 federal exceptions, okay? Again, number 1, if you are required by law to do something when you find that an employee is tested positive for cannabis, has engaged in cannabis use, whatever the case may be, you can go right ahead and continue to discipline and discharge and not hire on that basis. And then again, number 2, if you've got a federal contract or you will lose federal funding by not disciplining and not discharging, then you are okay to go ahead and continue to discipline and continue to discharge because of that cannabis use. And now the third, which we or actually one thing too, this is important before we go to the third. Remember, what this does not allow you to do. We heard a lot about this in the beginning. What these federal safe harbors do not allow you to discriminate against legal cannabis users solely because cannabis remains illegal under federal law. So what do I mean when I say that? We had a lot of employers who have said to us after the passage of the MRTA, well, Chris and Mike, what I'm going to do is we know that it's still a Schedule I narcotic under federal law. We're going to adhere to federal law, and we're going to continue to treat this. We're going to continue to drug test, and we are going to continue to discipline, discharge, and not hire based on cannabis use. And the answer, in my response, to which our response is no. That's now illegal. You cannot rely on the fact that it's still illegal under federal law. If you're here in the state of New York and you've got employees that we talked about, and you cannot rely on that. You have to follow this law unless you fall under one of the three exceptions we're talking about. Okay. And again, before we get to the third exception, let's just go through some of this as well in the federal exceptions. Again, legally mandated drug testing for marijuana can continue. The classic examples are United States Department of Transportation. There's rules and regulations there that make it okay. It's mandated for drug testing. Same thing with the Department of Defense. Same thing for the nuclear regulatory positions that come into play. Anyone who's connected with those agencies or has contracts with those agencies or who operates under the purview of DOT, you can and should continue to test and discipline as required under those legal mandates. We've had a lot of questions about CDLs because this is where it really comes up a lot. So, again, as many of you probably know, a CDL is someone who operates a commercial motor vehicle that's got a gross weight of 26,001 pounds, is designed to transport 16 or more occupants, or is of any size and is used in the transport of hazardous materials that require the vehicle to be placarded. So if you've got a CDL, you're covered under DOT, and DOT allows you to be able to test and discipline and discharge as necessary. So railroad employees are also covered by this. We won't, you've got the slide here to see who constitutes a railroad employee under DOT. You've also got airline employees under DOT, and everybody that includes, as well as pipeline employees and transit employees, and also maritime employees. So if you're covered there, if you run into any of those individuals, or if you employ anybody that falls in one of these categories, you're covered under the DOT regs, and you can continue to test for marijuana and discipline or discharge appropriately. So again, before we get into the third exception, under the two federal exceptions, review your requirements, right? You need to understand what your federal contracts are. You need to understand, to the extent you get federal grants, what they are, and see whether there are any conditions that require you or mandate drug testing. Because if there are, you don't want to, it gives you an out. It gives you an ability to continue to test, continue to discipline and discharge. Also, be aware if you're covered by DOT or you're covered by any of those other regulations that we talked about. Know what your obligations are under those laws and whether or not those obligations require you to be able to go ahead and test for marijuana and discipline and discharge accordingly. And then the last is what I refer to as the impairment exception. Okay, so this is the one that generates the most discussion, and Mike's gonna kind of talk about this in more detail going forward. But you are also allowed to test, discipline, and discharge for marijuana use if the employee, while the employee is working, manifests, and it's that term that Mike used earlier, specific articulable symptoms of cannabis impairment that decrease or lessen the employee's performance of the employee's tasks or duties. Okay, so that's number one. And again, what they also say in the MRTA is the employee, while working, manifests specific articulable symptoms of cannabis that interfere with the employer's obligation to provide a safe and healthy workplace as required by state and federal workplace safety laws. So Mike's going to go into this in detail, but just remember that example that I gave you about the individual who gets out of his or her car right before they go onto the production line, and they light up a joint, they come in high as a kite, now they're ready to work, and that would fall under this. You don't have to, those people who demonstrate these specific articulable symptoms, which Mike's going to talk about in detail right now, you can absolutely test, discipline, and discharge those individuals, because it's a safety issue. It's a safety for themselves. It's a liability issue for the company. It's a safety issue for others that is completely allowed under the MRTA. So that I'm going to turn it back over to Mike, who's going to talk about these specific articulable symptoms a little more and get into the issues of drug testing.
Great. Thanks, Chris. So let's talk a little bit about drug testing considerations here. And I'll pick up right where Chris left off, these specific articulable symptoms. The guidance from the Department of Labor states there's no dispositive or complete list of symptoms of impairment. Rather, what the government is looking for are things that one, you can articulate and are based on objective observations that somehow indicate the employee's performance of their duties are decreased or lessened at the end of the day. So we sent around an appendix to the materials. It really is a reasonable suspicion checklist. And you will see there are like physical manifestations, behavioral manifestations. And I didn't count how many there are, but I think it's close to 150 that are listed there. And I don't even think that's a complete list. So if you believe you have an employee who, might be impaired, you pull them aside, bring them in a conference room. I think 2 managers complete this sheet and go through what they observe. And if you think you got enough, you can drug test for THC. If you don't want to drug test for THC, you don't have to still, but this is one way that you can do that. Also, the statute, to be clear, does not prohibit drug testing of other illegal substances. So, some employers may say, nah, we don't care about THC. We're not going to test, because you can't unless you fall into one of those 3 exceptions. But some of them may just say, even on this other one, we're not going to do it. And that's okay. You just might be missing something. The other thing I don't want the manager to do is guess why the employee is impaired. It could be illegal drugs. It could be alcohol. It could be they had a bad night's sleep. It could be they're having a reaction to a prescription or non-prescription medication. It could be that they are experiencing some type of medical condition. You don't know, and I don't want you guessing. One of the things you'll see on the symptom chart that we gave you is ask them, dude, are you high? Dude, are you impaired? What have you been smoking? What'd you take? When did you take it? Who gave it to you? I think all those questions are fair to ask. And so, like, they may say, I smoked a joint at work. I bought the joint from Johnny at work. Do I really want to drug test him, or do I want to just go and terminate the employee based off of the admission? Sometimes you don't need to do the follow-up drug test. There's really no reason to. Remember, you all have smartphones. Can I record this interview? Absolutely. And it's going to be hard for the employee to wiggle out of basically what is a confession of drug use in that regard. So we gave you the list. Take a look at it. One of the things we offer is training for managers on going through the symptoms and how to go about doing the interview, just so you're aware of that. And again, remember, it might be a medical condition. And if it's a medical condition, it may amount to a disability under federal and state law, and the employee may have some protections. Make sure you always consider the disability angle on this. If the employee somehow says, I'm disabled or have this medical condition, just remember that those are there because it's important. Don't lose sight of the forest through the trees. Just because an employee is impaired does not mean it is drugs or alcohol. Just remember that. You got to get to the bottom of it. So let's stick with the operation of a heavy machinery in an unsafe manner by a heavy machine operator. If they're operating unsafely, it is clearly an example of a specific articulable symptom. Remember, you don't have to wait for someone to hurt themselves, to hurt others, or to destroy property that belongs to the company or otherwise before you can intervene. One of our former district court judges, Judge Munson, wrote a very simple decision. It said that, but it also said, the forklift driver was operating the forklift at a very high rate of speed. As he took a turn too fast, witnesses heard the operator go wee, like he was having fun driving the truck. The judge said, you can intervene. That is clearly something that you can do. So let's not throw common sense out the window here. Observable signs of use that do not indicate impairment on their own cannot be cited as an articulable symptom of impairment. On their Facebook page, the employee posts a picture of him holding a joint. That's it. Doesn't smoke it, doesn't say he smoked it, but it's something that you can see. And that's not enough to get a specific articulable symptoms. Only those that are observable objectively and that you can somehow document and tie into performance are what we're looking for. Employers, you are not prohibited from disciplinary action against employees who are using cannabis during work hours or using employer property. And that's one's important because that doesn't have to be during work hours. The employee could go live on Facebook Saturday morning, start smoking joints, and he has a company shirt on, or the company flag or logo may be in the background. That's using employer property, and you're going to be able to act on that. The smell of cannabis on its own is not enough. The employee may say, I got sprayed by a skunk. Skunk and cannabis smell pretty much alike. I hate to tell you this in that regard. And individuals that smoke hemp, the scent is very similar and doesn't give you any impairment at all. So just the smell is not enough. Might I watch the employee? Might I pay more attention to the employee during the day? Absolutely. I might even send him home for a foul smell. I mean, I have actually been in a workplace, my former law firm, I was on the 15th floor. I get off the elevator and I'm met with skunk smell. And I'm like, how is this possible? We had an employee that got sprayed by a skunk before she came in and thought it was a good idea to come into work anyways. We sent her home. So if the smell is offensive and that's all you got, out of an abundance of caution, you can send the employee home. So just keep in mind your other options here. New York has issued guidance, as Chris has indicated, unless you fall into one of those three exceptions, you can't test for cannabis. A test for cannabis usage does not show current use. Depending on how you test, it simply shows it at some point in the background, in the past. Can the employer test for cannabis? No, unless you fall into the exceptions. Can an employer drug test an employee if federal law allows it? It's not a question of allowing it. It has to mandate the test. So federal law allows drug testing. The Americans with Disabilities Act, the guidance issued by the EEOC, clearly states you can drug test. It's not a violation of the Americans with Disabilities Act. That's not enough. We need to point to, like Chris went over, the DOT statutes for pipe workers, for CDL drivers, for maritime employees, for railroad employees that require the test. That's what we're looking for. If you don't have a drug testing policy and you want to develop one, or if you have one and you want to bring it up in compliance, things I want you to consider in doing so: the selection of a lab, is it reputable? The medical review officer, how does the medical review officer operate? Who is the medical review officer? I'd like to check the state database to make sure he's not some disgraced physician. If you have the pleasure of having a union, please remember drug and alcohol testing requirements should be negotiated with the union in that regard. I always ask the question of the employer, what are you testing for? Some employers don't realize that all drug tests are not created equal. There are panel tests and what are called custom tests, where you target a specific illegal drug and that's all you want to get tested. Don't listen to your employee. If the employee said, if you decide to drug test and the employee said, I just smoked a joint, all I'm going to test for is THC. Well, his drug dealer lied to him. Shocking. It was a cocaine-laced hemp cigarette. And he might test negative for THC, but would test positive for cocaine. But you need to do the correct test in that regard. Don't listen to your employees, what they're on. I want a very broad and comprehensive drug testing panel. I would use the 15 panel. The level that is being tested for is also important. Not all drug testing facilities test at each the same level. So it's possible that someone could pass in one test and fail another based simply on the sensitivity level in that regard. How is the facility testing? Blood, urine, hair, saliva. You need to know, and you need to know how far the look back is in what regard. Employee admission, I've already mentioned this. If the employee admits, do I really need to test, especially if you got it on your video phone? I say not. I actually had a client that did that, thought they were doing the right thing. There was only one problem. They didn't realize there were multiple panels for drug testing, and they only tested the 5 panel, but they needed to test the 15 panel, and there was a negative, a negative test result, and then they wanted to fire him. I said, well, you sort of screwed yourself. You tested without calling me for something, and you cheaped out. You didn't want to spend the extra $50 for the 15 panel, which would have had a positive drug test result. So remember, your smartphone's always important. The timing of the test, the quicker you got to get the person there. The more time you give them, the more likely it's out of their system. Also, getting to the test, things to consider. You don't let them self-drive if you think they're impaired. Have a manager drive, or maybe take a Uber or taxi or something like that. A 5-panel drug test, here's what is tested. If you don't fall into an exception, or you're doing pre-employment testing, you have to stop testing for THC at this time. Here's the 10 panel, includes everything that's in the 5, and here's the 15 panel. It includes everything that's in the 10 and the 5 as well. And again, if you were to find this in an employee's desk, is there a problem here? Oh yeah, it's pills and a needle. I don't know there's a problem here. What are the pills? Oh, they're Tylenol. And why do you have a needle? I'm diabetic and I have to take insulin. Would it raise as, should you ask a question of the employee? Sure. Should you jump to drug use? No. You need to be deliberate in your approach. Absolutely, I'd ask questions. Why do you have a hypodermic needle? What are these pills in an unmarked container? And maybe we flip them over and they all say Tylenol. So don't overreact, but don't underreact. So some workplace policies I would like you to consider, and they could go in your code of conduct. You might have an illegal drug use policy that's a standalone. I don't care, as long as you have it. Make sure it addresses other prescription meds. So Johnny is taking his mother's prescription medication. That should be a violation of your policy. Prescription meds, I also say sometimes it's advisable to put in your handbook something along the following. Dear employee, please tell us if you are taking any medication, prescription or non-prescription, that affects your ability to safely perform the essential functions of your job. Put the burden on them. That's a legal policy. This one's illegal. Dear employee, please tell us any prescription medications you are taking. That's illegal. That gives you birth control, that gives you Viagra, things like that. So don't go overboard in that regard. Please remember your anti-smoking policies should also cover vaping and e-cigarettes. Smoking is banned in your building and in company cars or vehicles. Can I have a policy that prohibits cannabis use at work? Absolutely. It includes company vehicles, rented space, employers' property. The interesting thing is I was like, what about in my personal vehicle parked on a company car or parked on a company parking lot? I think you can, but they left that out in this list. I think we just simply have to be careful. If the employee doesn't let you search their car, I think you discipline them for not letting them search your car. I don't think you do random searches of cars, but if you see something like one of my clients, the employee said, hey, to a manager, could you help me get something out of my car? And they open up the back and there's bags of, it literally turned out to be cocaine. He was a major drug dealer. He's like, and he shut the thing, and they called the cops. He came over, big arrest. So you might discover things that just happen like that. You can act on it. Code of conduct issues. You can't possess marijuana at work, can't be under the influence of marijuana at work, can't use marijuana while working, can't possess, sell, use, etc. drug paraphernalia, bongs, a little roach clip. How about Chris showed you that photo, the new normal? I think the guy had a little headband with the pot leaf on the front. I think you can ban that. I don't necessarily have a problem with that. You can't sell or auction marijuana while at work and before you left. We've had that happen. Someone was auctioning off their medical marijuana, which we were pretty sure was a felony, and we wound up just firing him. Can't barter for marijuana at work. You can't possess drug magazines at work. I'm going to give you some examples in a minute. You can't come to work smelling of marijuana. Hygiene still prevails. I mean, if someone reeks at work, you can send them home. So you can't come to work like that. And you can smoke all you want, the pot you want at home, but when you come here, you can't smell that way. You don't want your employees purchasing THC products on your computer network or your computer equipment. Chris mentioned the Lee, Massachusetts dispensary. You can order online, all right? And you don't want them using your computer to do so. You can't possess at work any product containing THC, candy, lollipops, gummies, cookies, brownies, etc. And I'm going to show you some photos in a second. So pot cookies, they look like regular chocolate chip cookies, but they're laced with pot. I don't know how you're going to discipline this or monitor this unless your employees start having reactions. I simply say be leery of anything that employees leave on their desk for you to eat. THC now is in drinks. It is in gummies. It is in beer. It is in lollipops. It is in candy bars. And take a look at these candy bars. They make it look like Butterfingers or Twix or Milky Way. It doesn't say Milky Way, it says Munchie Way. It doesn't say Butterfingers, it says Butterfingers. It doesn't say Reese's Pieces, it says Rasta Reese's. They make it look like a candy, and they're disguising it. I pulled this off the DEA's website. I can't purchase pot online. Oh, heck, you can't. Here's some other websites in addition to the Lee dispensary one that I mentioned. Drug magazines also exist online. And here's some examples. Vegas Cannabis, it's mainstream. Photo of Mike Tyson smoking a joint. Well, just because I can go to Borders or Barnes & Noble and buy a magazine doesn't mean I can't prohibit it in the workplace. I can buy Playboy or Penthouse, assuming they still publish that, at Barnes and Nobles. Doesn't mean I can bring it into the workplace. High Times is another example. Here's some examples of drug paraphernalia to be on the lookout for, and to ban in the workplace. Can you as an employer prohibit cannabis use during meal or break periods? Just as Chris indicated, absolutely. The work day and work hours for purposes of the recreational activity law includes meal and break periods, but you don't have to pay them for it in that regard. Can employers prohibit use of cannabis during periods on which they're on call? Employers, if it's a work hour, you can in that regard. If they're expected to be engaged for work, you can also ban it in that regard. For remote employees, can employers prohibit use in the work site? Well, typically the private residence is not the work site within the meaning of the labor law. However, you may take action if the employee is exhibiting articulable symptoms of impairment during work hours, and may institute a general policy prohibiting use during work hours, no matter where you may be. How would I, if someone's working remotely, how would I know they're impaired? You can be on a call like this, and you simply discover it by being on a Zoom call with them. Can I prohibit the use when the employee uses a company vehicle? Absolutely, no ifs, ands, or buts about it. Can employers prohibit the use of cannabis outside the workplace? No, unless they're permitted to do so under the labor law, like under the federal exceptions that Chris went over. Can employers require that employees promise not to smoke pot as a condition of employment? Very creative, but the answer is no. Such a waiver is illegal under the labor law. Are existing policies prohibiting use permitted? Well, maybe and maybe not. You have to update your drug and alcohol policies and your other policies to reflect the current changes that Chris and I have went over here with you today. Are employees required to hire someone back that was previously terminated for illegal use of cannabis that is now legal? No, there's no hire back requirement in that regard. So with that, we'll stop there, see if there are any questions. And again, if you think of something in a day or so, feel free to email us. Those of you watching this at a later time, just a reminder, Chris's contact information, my contact information are in the early slides, and feel free to follow up with a general question. But you do have some homework to do. You do need to get your policies and your handbook updated. And I would also say, seriously consider management training on specific articulable symptoms, what managers can do, what can't they do in that regard. So with that, Chris, do you have any other comments before I turn it back to the chamber to see if there are any questions?
No, I think we covered it all.
Awesome.
Okay, thank you, everybody. The only question that was in the chat was from Alan, asking if a copy of the Zoom will be sent to us, which I did respond. We will post that on our website, as well as email you the Zoom link of the recorded seminar. You can also visit chemungchamber.org to register for other upcoming webinars or find the recordings of previous webinars. For anyone interested in chamber membership, please contact the chamber at info@chemungchamber.org or call 607-734-5137. Many thanks to Michael and Christopher, and to everyone for joining us today. Have a great day.
Thanks, everyone. Thanks, Chris.
Thanks, everyone.